Hey, great to be with you today. We've got Robert Capovilla and Mickey Williams from Capovilla and Williams, military lawyers extraordinaires. Everybody's wide awake now. I want to go back. We had an earlier episode today, and there were some bold predictions about Ohio State football. So let's just get them on record, Mickey. I think. What do you think their record will be this year in 2021? Because they won't be playing in 2022. That'll be the championship, and they'll be out.
I appreciate that you are skipping over the biggest news of the day, which is that Mickey Williams is wearing a pink shirt.
That is big news.
During the podcast. Now, Matt, you and I are Midwestern guys. Okay, we don't wear a lot of pink.
Yeah.
I don't know if I should give him credit for being so bold as to wear pink.
Yeah.
He was an Army Ranger. I don't know if I should make fun of him for wearing pink, but what I do think is I would have a lot more respect if he was wearing those Arnold 1980 sunglasses that he loves to wear all around. That would make the pink much more legit in my eyes.
My wife likes this color on me, she tells me. And the reality is, I thought this was a blue shirt, honestly, and I put it on.
Yeah, I have that problem, actually.
Yeah,
I'm one of the 8% of colorblind males out there. But, well, you know, I think you got to be real careful commenting on anybody's opinion or appearance these days and giving your opinion.
That's
no
true.
matter what they're wearing.
That's true.
But because it's Mickey,
all right.
You know, I think we can get away with it.
Ohio State football. The only reason that you guys got me to agree to a podcast is I thought we were doing a podcast on Ohio State football. I'm kidding. All right. I think we lose 2 games this year. I think we lose 1 in the regular season. I don't think you can look past Oregon. They're very strong defensively. Mickey does not think his team can win a big game. Mickey's from Oregon, went to Oregon. I think Oregon's going to be a very tough test for Ohio State. And I don't think we're going to have the chops this year in the secondary and the back seven to match up with Alabama or Clemson or maybe even Oklahoma if we meet them in the playoffs. So I think this is going to be a little bit of a down year. But the talent is extraordinary at Ohio State.
Talking about the playoff, aren't you just getting ahead of yourself at this point?
Listen, you're a Michigan fan, okay? Michigan State, excuse me. The playoff to you guys
there's
is
a big difference between those two, by the way. There's little brother and there's big brother.
If you live or root for any Michigan team, the playoff is like winning the lottery. It's like the biggest thing that could happen in your lives. To Buckeye fans, you know, you expect to win. We're winners. We're champions, right? I mean, Urban Meyer, Ryan Day, yeah, we're going to be in the playoffs, 100% in the playoff. Now, are we going to beat Clemson this year, 48-21 or whatever it was? Probably not. But we do have an extraordinary amount of talent, and God bless the Ohio State Buckeyes.
Mickey, do you get those texts every time they recruit a 5-star player? Do you get those texts from him too? Like,
man, if you saw some of the texts I got about Ohio State from Rob, I think you probably be dead, man, because some of the stuff that he sends to me is quite obscene in a good way, in a good natured way. But yes, no, I get him and I give it right back to him. I think Rob feeds off the competition, and when I don't give it back to him, it's like starving a flower. You put it in the closet and it gets a little bloom kind of goes off.
He needs that.
He needs it, so he's like trying to rouse me. He like sends me this picture of Marcus Mariota crying.
That's right.
After getting hit or something, like it's gonna offend me. I'm like,
he was. And,
like it's gonna offend you.
Yeah, I was like,
and I send him a clip of Ezekiel Elliott like running over 3 of their linebackers at one time that I love to send him from the 2014 national title game, which I watched in Korea, by the way, because I was overseas at that time.
Yeah, so he sends me these things, and and Rob's right. I don't think they're going to beat Ohio State because I know the level of talent that's on that team.
You're talking about your Ducks.
Yeah,
I'm talking about your Ducks.
I'm talking about the Oregon Ducks. And I love Oregon, but it just seems like we can't win the big one, man. Like we've been there.
But they're building. They've got a great recruiting class coming in.
But they're getting out recruited. I think we're only 7 in the rankings.
Yeah, but that's elite though. I mean, you guys are bringing in some serious NFL talent.
Here's our problem. We don't have a good quarterback. Right.
Yes. Agreed.
And we do have a great offensive line. And our defense is starting to really, really explode. But we lost a great recruit to Ohio State just like 2 weeks ago or something.
Think about the regret that poor kid's going to have.
Oh, please. Oh, please.
Yeah,
you know,
he left the state where like all the drugs are legal.
Spoken like a Michigan man. But by goodness, the folks that watch this podcast do not want to hear us talk about college football.
We're going to have to cut all this out. We're going to have to edit
I want
out.
all of this in. But
you want predictions on record.
I do. I want predictions on record, and I want to have a podcast after the Ohio State-Oregon game where I'll be decked out in nothing but Ohio State gear.
You guys need to do a tattoo bet, right? Like,
no, we don't talk about tattoos as Ohio State
Somebody
fans.
gets a tattoo of the other guys.
Is not something
Rob actually has a tattoo.
Okay.
Oh my gosh.
Rob has a tattoo
I think he does.
that I got when I was about 17 years old.
This could go real bad from this point forward.
I was doing things at 17 I should not have been doing, and I ended up with a tattoo, and my mother was very upset. Kudos to my stepdad for having my back that night. But anyway, let's talk about what we're here to talk about.
I agree. Before we jump into that, though, I think we should have an episode where you get that tattoo lasered off live here in studio.
No, I don't think so.
I would love to see that.
No, I don't think
mean,
so.
you can do that stuff easily. Now it's painful, but
Yeah, I don't think
Sam
so.
agrees over there.
all right.
Yeah.
So let's
Sam, our sound guy,
yeah.
agrees.
Yeah.
So let's jump into today's topic,
Yeah.
which is actually a very important and interesting one.
Yeah.
You guys have handled, you've had hundreds and hundreds of clients and cases that you've worked over the years, both when you were in the service and out as civilian counsel. You represented dozens of clients in really complex cases. So it takes a bit to surprise you, or I guess a bit for you to kind of pause and say, uh-oh, what's this? But this case, it sounds like, does just that.
Yeah.
And it's, I guess you could term it, what do you do when a judge goes rogue? And
Yeah.
I'm not going to get myself in trouble, but it is an interesting case. And so today we're going to talk about it. We're going to talk about the facts, what's happened, your guys' involvement in it, how you think it'll shake out. But it's a fascinating case. It's been covered, too, pretty widely covered, I think, in the media, at least the ones that cover military justice.
Yeah, no, and I think I was surprised when I read the ACCA opinion in U.S. v. Hannah, knowing we know who the judge is. We're not going to mention the judge's name. We're not here to bash any judge, okay? By and large, these military judges are fantastic lawyers and people and officers. But, this case, along with, U.S. versus Voorhees, Mickey, is probably the two cases that really put us...
I forgot about Voorhees.
Yeah, that were kind of shocking. So we do have an interesting perspective on U.S. v. Hannah, which was a case that was decided by ACCA. Hannah has hired us to handle his trial, his remand. We're not going to discuss anything about that. We're going to really just talk about when you're a defense attorney in the military, what do you do when the judge starts acting crazy, which I think is what happened here. So I'm going to cover the facts of the case, very basic. I don't think the facts are overtly important. I think the judge is more important here. But sex assault case, not a great sex assault case for the government. I think it's a sexual assault case where most people who do this for a living would feel confident that the defense had a good case, a good strategy. But bottom line is that as this case developed, they decided to go judge alone with a judge who has a very, very victim-friendly reputation in the military. And as the case progressed, the judge became quite hostile to the defense attorneys.
Yeah, and you guys didn't handle the defense in that original case.
No.
Correct.
This case is from October of 2016.
Okay.
We had nothing to do with the initial trial, but I want to talk a little bit about...
It was that long ago?
It was that long ago, yeah. It's a long time ago. Ago. So I want to talk a little bit about what ACCA kind of highlighted and what happened during that trial. They essentially did a factual sufficiency and a legal sufficiency review. Those reviews are de novo. We're not going to talk about them. They didn't, ACCA didn't have any issues with really the sufficiency side of the case.
But if I could back you up just for a second, Rob. So there's a trial that happens in this case.
Right.
And then that decision goes up on appeal, right?
Correct. That decision, because he was found guilty, in a sex assault case, he was sentenced to 3 years, dishonorable discharge, I believe. It goes up to ACCA. Okay. So now the appellate court has made a decision, and they have remanded the case back down to the trial level, essentially because they did not like the judge's conduct towards the defense counsel.
Okay.
And we can get very legal about it. We can talk about the different standards.
I think it went more than they didn't just like her. She did some pretty bad.
She did.
Yeah, she did some.
And let's talk about it.
Yeah, let's get into it.
So let's get specific.
Because it's well documented. Right?
It's well documented.
It's well documented.
Okay, so here we go. I'm going to quote some things. Bear with me. All right.
Yeah, this is crazy.
Quote, throughout the trial, and especially when the defense cross-examined the victim, the military judge repeatedly sua sponte interrupted, criticized defense counsel, and sustained her own objections. I just want to talk about that for a minute. the judge is objecting and then sustaining her own objections, which happens sometimes, right? Judges do have the right to monitor the court martial, make sure things are done fairly.
Sure.
But I don't know how that would work. I guess
listen, if you're doing a cross-examination and you object on yourself, like that is a weird thing. Now imagine objecting and sustaining it. You know,
well, if you're the defense counsel, what are you going to do, right?
Yeah.
You're in the middle of a cross-examination of the most important witness in the whole trial. The client's rights to confrontation are being exercised, and the judge goes, excuse me, objection, hearsay. Your Honor, I'm sorry. Is that objection coming from you? Yes, it is. Does the court wish to hear my response, or has the court made their mind up on their own objection? The court's made their mind up on their own objection, but I'll hear you just because we should hear you. Overruled, sustained. Defense counsel continue, right?
Yeah, that's
Yeah.
crazy.
Literally like sustaining.
Isn't that wild?
Yeah,
It's-
I mean it.
So
Well, it's wild to us, I guess.
Well,
I
it's wild to me. It sounds almost like a TV show, almost like something
Like
that
a
you would
comedy.
see in
It sounds like a
movie.
comedy
a little
to me.
bit. Yeah.
Yeah.
I mean, honestly,
well, let's get through some more of these because they get a little bit more entertaining. The military judge, Sue Sponte, criticized defense counsel for the length of her questions, criticized her attempts to impeach, and limited her ability to explore what appeared to be relevant topics. Quote,
Yeah.
the military judge also, Sue Sponte, interjected herself into a line of questioning about what witnesses told CID about the two pair of underwear, telling defense counsel, quote, don't try to repeat that again. Try to turn it into something else. My problem, and we'll talk about these as we go, and then we'll kind of talk about what to do. But my problem with that last quote, don't try to repeat that again. Try to turn it into something else. Mickey, our client's sitting there as you're cross-examining, right? Life on the line, livelihood on the line. And essentially, let's break that down. Here's what the judge is saying.
I know where you're going with this.
Yeah, the judge is saying, I don't trust you, defense counsel.
Yeah.
I don't believe you. I think you're sneaky. I think you're trying to pull something here. And that is the judge putting her hand on the scales of justice. Now, there was no jury in this case, but my goodness, what is the client thinking when they see the judge essentially, in her own words, say, defense counsel, I don't trust you here.
Yeah. This is a judge alone case, right?
Judge alone.
Yeah. I can only think it's got to be the most horrifying experience ever to be that client. Almost like cutting a tree down on your own house. Like you see it, you start.
That's right.
There's nothing you can really do. You just see the trees coming down and it falls and it collapses. Because you go into this thing and you're thinking, hey, this is a judge. They're going to be fair. They're impartial. Attorney's telling me, hey, man, this is a good judge. We got a great case. And then it just starts falling apart. And there's nothing, there is not a dang thing you can do as the client. You're just sitting there watching this happen.
And there's so much on the line.
My God, it's got to
with
be
this
horrifying.
person, right?
So
I mean,
much.
it's their life, really. I mean,
It's quite tragic when you think about it that this could happen, but it gets even a little bit more egregious. So then at some point during the trial, the defense objects under Sixth Amendment grounds, a case called U.S. v. Katso, right? And they're basically saying, hey, we don't think the government's DNA expert is the right person to testify.
Yeah, confrontation, right?
Confrontation
Okay, yeah.
clause. And they have a Katso debate. And we're not going to get into the legalese of what Katso is, but essentially it's a confrontation issue. And the judge says to defense counsel, quote, I'm not going to penalize your client for your poor decisions. The judge is openly criticizing the defense for bringing this objection up during trial and apparently not bringing it up beforehand, which I think is wrong and not supported by the rules. And quite frankly, usually confrontation objections happen once the
At trial.
witness testifies.
Yeah, it's right there.
Now, it gets a little bit worse than that. And then she goes, quote, because I thought the defense may pull this, may decide to object to this in the last minute. At that point, the military judge announced the government's DNA expert would not testify until the next morning in order to allow the government counsel sufficient opportunity to ensure that the expert's testimony was consistent with Katso. That's the judge being a little bit concerned that the government is not going to meet the standard under U.S. v. Katso about what personal knowledge the expert has to have in order to satisfy the confrontation rights of the accused, and saying what? Government, don't worry. If you need more time to perfect your case, even though this investigation's been ongoing for 2 years, if you need more time to perfect your case, I'll give it to you. No worries. But defense, shame on you.
So she's, or he, whoever this judge is, right, saying to the government, go prep your client, essentially. Make sure that
Go prep your case.
Yeah, go prep your expert. Make sure they pretty much woodshed him.
Right.
Make sure he's going to stay in line with the case law.
Yeah.
Right.
And there are times when time should be given to counsel, right? There are times in a case when there should be some sort of delay.
Of course.
But this sounds more like eliminating a strategy of the defense.
And then listen to this quote. Government, I will let you know that should this court determine that her testimony is not sufficient, you will be given an opportunity one way or another to get the right witness here, whether it's her or someone else. This investigation's been going on for years at this point, I believe.
Yeah.
They've had years to get it right.
Yeah.
I'm sorry, but that's the judge putting her finger on the scales of justice. If the government after 2 years couldn't get this right, they shouldn't be given a get out of jail free card. But let me then bring up this, and then I want, Mickey, kind of your thoughts on comparing and contrasting how she treated the government defense.
Oh, yeah.
After the DNA expert testified for the government, the defense had an expert there. We knew the expert. Great guy, right? One of the most experienced experts in all of courts martial. I love him too. Okay? And it is commonplace after a government expert testifies to go, Your Honor, give us 15 minutes. We need to talk to our defense expert because DNA can be kind of complicated.
Sure.
And the expert may testify to things on the stand that were slightly different than what the pretrial interview revealed. And you need to make sure you're ready.
Yeah.
Mind you, government, I'll give you as much time as you need to get your case right. Don't worry. I got your back. Defense counsel. Your Honor, may we have 15 minutes to consult with our expert? Quote, you may not. You can consult right now. This witness is not a surprise. And you told me yesterday you've talked to this witness before. So we'll rest in place right now.
And this is a judge-alone trial.
Judge-alone trial.
Yeah.
Let me tell you. Well, Mickey, why don't you give your thoughts on that?
I think this judge is going rogue, like we said at the beginning. I think that she had an interest in the outcome of the trial, which is what you're not supposed to do. You're supposed to treat both sides fairly, and you're also supposed to be very aware of the rights of the accused, and you have to make sure not to give the impression to the accused or to anybody for that matter that you are partial. And I don't think this judge gave a hoot about that.
I mean, it sounds like one of these instances would be a bit surprising, let alone, I mean, Rob, you've gone through 4 or 5 of them. There may be more. I don't know from the opinion, but I mean, it's somewhat shocking behavior.
RCM 801 and Military Rule of Evidence 611, and in part Military Rule of Evidence 104, right? Give the judge a lot of discretion and how they're going to run their courtroom, right? And they have to do so in a fair and impartial manner, and they must avoid undue interference with the party's presentations or the appearance of partiality. That's what RCM 801 says.
Which is a little vague, right? And it gives them a lot of leeway, I would assume.
Right. And it's not uncommon for judges to get on the government or get on the defense. It's not uncommon for the judge to correct you on certain things. And it's not uncommon even times to have a judge show you up to some respect, right? I mean, it's their courtroom, right? It's their courtroom. But I've been in a lot of courtrooms. Mickey's been in a lot of courtrooms. I've never had a judge deny us the opportunity to speak to our expert after the government's experts testify.
Never.
Never.
Yeah.
I've never had that. In fact, usually the judge takes it upon themselves before they even let us cross-examination to say, defense, do you need some time? Because a good judge is going to understand, hey, DNA is complicated. And, I need to make sure that the defense counsel is ready to do this cross-examination, because when you cross-examine an expert, you're stepping into their field. Much like when you jump in the ocean, you're now in the shark's domain, right?
Yeah.
When you cross-examine an expert, you're crossing them on something that they know a heck of a lot more than you know. So this was a shocking, this was shocking to me to read. And it kind of lends the question, Mickey. You're in a courtroom. You're fighting hard for your client. Now, I think a panel's different. If this had happened in a panel, it'd be egregious.
It'd be a mistrial for sure.
It would be egregious.
Yeah.
But this was judge alone. All right. So keeping that in mind, you have a judge who is not letting you ask questions on cross-examination. The facts say she interjected herself more than 20 times. Mickey, you're in the courthouse and she says to you, Mr. Williams, you are not going to be given a chance to speak to your expert. What in light of the objections that she herself levied at that moment, or maybe even before that moment, what are you going to do? What do you do?
Yeah, the first thing I'm going to do is look at my client and say, yeah, this judge is whack. We got to get this judge in control. And you have to do that sometimes as a defense counsel. You have to try to convince the judge that, hey, they're screwing this whole thing up. So what I would do is what's called, I think it's RCM 902.
That's right.
I would file for a motion, and you don't have to file paper. Sometimes this judge might have been like, well, you got to write that out. You got to write that out.
Yeah, right.
What are you doing? You can do it anytime. And you would just lay out the problems that you're perceiving with the trial, that this judge, basically what 902 says is that if you have reason to believe that the judge is acting in a way that is unfair, right? He or she is being partial, then you have a right to challenge that judge, right? You have an opportunity at the beginning of the trial, and then you have an opportunity throughout the entire trial.
At any point during the trial, at any point.
And so you raise this and you get it on the record, and you point out the issues to the judge, and the judge, if it's a decent judge, will be thoughtful about it, think about it, and probably reorient themselves if they're seeing that. And then they'll make findings of fact on the record. But what's interesting is the judge then makes a decision whether or not they are in fact being partial.
Yeah.
Right?
Which always seems kind of odd, right?
Yeah. It's
You're
like,
not doing this properly.
Yeah.
Do you agree?
Judge, you're screwing this up, man. And like, oh, yeah, I better fix it. But I think this judge, if he had done that, would say, no, I'm being totally fine. You're the one out of control. How dare you? And so all you're doing is raising the issue for appeal. And that's
that it? Are you protecting the record at that point?
That's pretty much, I guess you might be able to do an interlocutory appeal. I've never seen that.
I don't know the answer to that.
Yeah, I've never experienced
What is that when you stop everything and you go up right then and there?
Yeah, so RCM 902 Delta is what we're talking about here, right? The procedure. And here's what it says. For the judge advocates who are going to be listening to this and want hard rules, right? Because sometimes we get criticized for being a little cavalier about these rules. So here we go. The military judge shall, upon motion of any party or sua sponte, decide whether the military judge is disqualified. No preemptory challenges are necessary or allowed. These challenges may be raised at any time, right?
That'd be funny.
Each party shall be permitted to question the military judge and to present evidence regarding a possible ground for disqualification. So, if this were me, I would at some point during this trial most certainly requested an Article 39A, a motions hearing, and I would have essentially voir dire the judge because the rule allows that. Any party may ask the judge questions or present evidence. And I think, Mickey, it would look a lot like the voir dire that we have of potential panel members.
Yeah. And I think the standard's the same too. I think
right. I think
it's
similar.
The LGM.
I think it's similar. I don't think the LGM qualifies when you're talking to the military justice or military judge.
No, but
I don't know.
I think they use the same standard though. I think so. The LGM is a liberal grant mandate. Basically, when you challenge a juror or a panel member, you're looking for two things: bias or perceived bias, right? Actual bias, perceived bias. If you can't find that, if the judge isn't willing to grant you that, but there is something off with the panel member, you can say, well, judge, under the liberal grant mandate, I believe this juror should be struck. And essentially the liberal grant mandate says, well, let's look at this juror objectively. Let's imagine we're somebody in the gallery, in the peanut gallery, watching this trial unfold. Would that person believe that it would be unfair to have this juror sit on the jury? And if so, on close calls, always on close calls, the judge is supposed to grant it.
Yeah.
Right?
Well, and CAF looked at it that way. I mean, that's in large part, that's what U.S. v. Martinez, which is a CAF case from 2011, it essentially says. But I think when you're in there litigating this motion during the trial, the liberal grant mandate, I don't think would apply to the judge.
No, you wouldn't say
Certainly
that.
not.
You wouldn't say that to the judge.
Right.
You wouldn't say liberal grant mandate. This judge probably laugh at you like, what are you getting the law wrong?
Yeah,
what are
that's
you
right.
talking about? Yeah.
But it may be an argument to make to the judge.
Yeah, I would make that
Well,
argument.
what Rob, you're saying is you can question the judge. You can stop the trial
yes.
and question the judge.
And
now, are you aware of this happening in any instances? Does this happen? Does that happen?
I have voir dired a judge on several occasions because the judge at the start of the trial, the script, when they're going over, when you're kind of getting there and you're going through the initial phase of a trial, they are going to ask if there's any reason for any counsel to challenge them, and they are supposed to, under the same law, RCM 902, they have to disqualify themselves from any proceedings in which they think, I think the rule says the judge's impartiality might reasonably be questioned. They're supposed to disclose to you if they have bias in the case.
Yeah. And they do this, real quick, they do this all the time.
Yes.
If they have worked with the SJA before.
Right.
Who's the lead prosecutor on the government side. They disclose it.
Yes.
And they say, I don't think there's any, we saw each other briefly, we worked together. Yeah, we were friends, but I don't have any. They lay out all the facts to say they're still going to be impartial.
Yeah.
Right.
And they do it for minor things, minor things. So
just out of an abundance of caution?
Yeah, out of abundance of caution, because they don't want something like this to happen.
And you have a right to question them at that time. And I have questioned. I have questioned judges when they say,
how does that go over?
So you got to be tactful about it, right? But getting back to these set of circumstances, I would treat it like a cross-examination. At this point in time, I would have felt that my client was being denied a fair trial. I would have felt that she's placed her finger on the scales of justice. And this is where I think civilian counsel matter.
Yeah.
I don't have to worry about what is that judge going to tell my boss. Okay. My boss is Mickey, right? Mickey and I are each other's bosses, and he's not.
I'm glad you know that.
He's not going to criticize me, right? And my wife, right? I guess the JAG court could call my wife. That might cause me some problems, but I would have at this point, I would have gone after that judge.
Yeah.
I would have cross-examined her on what is her experience as a judge advocate? Was she a victim advocate? How long was she a prosecutor? Had she ever been a defense attorney?
So you would have went deep.
Oh, I think at this point in time, I would have had to have stand up for my client in a very respectful manner. And I would have absolutely gone after that judge.
Yeah.
Because you have to. And Jerry Spence, one of our idols, right?
Yeah.
Says
Jerry.
He has a quote out there in one of his books that you respect the judge at all times, but when they are no longer acting in the interest of justice, you've got to do what you've got to do.
Yeah.
And I'm telling you right now, had that been me, especially when that judge would have said, no, you can't talk to your DNA expert, I would have absolutely confronted her. Ma'am, you just gave the government an infinite amount of time to get their case right, and now you're telling me I can't even have a break? And here's what else I would have done. This is from a good friend of ours, Bill Casera. This is advice he gave me. Matt, I'd stand up, look that judge in the eye, and say, ma'am, if you don't give me this break, I'm ineffective. Your call. What do you want to do?
Yeah.
And that's the power we have a little bit of civilian counsel. Like, for example, sometimes judges will make us travel across the country for an arraignment. Your Honor, I'm not going to be there. I can't make it to Hawaii tomorrow for an arraignment. Have it with either waive me or have it without me, right?
It's just crazy.
Yeah.
And I think that's something that you owe your client. You have to be courageous for your client, and part of that is standing up to a military judge.
Yeah, it's interesting that you draw the distinction between military counsel and civilian counsel and who they answer to. Because that's a fascinating, I think, difference in the work that you do and the representation that some of the clients get, right? I mean, they're going to get one or the other, and it can make a big difference. So where do you think it goes from here? Where do you think this case goes, without obviously divulging too much about your current strategy, but what do you think happens from here forward?
That's a dangerous question.
I think it goes to trial, man.
I know.
That's a dangerous question.
Yeah.
I think that
maybe just you guys are going to do a good job. Maybe that's the answer.
I think that Sergeant Hanna is going to get the justice that he is deserved to get. And I can tell you with certainty, our firm would not tolerate a judge treating us like this. We would have stand up and fought. And I don't know what Mickey thinks about that, but I'm quite certain he.
Oh no, dude! I would have
same
crawled
feeling.
under the desk, man. I would have hugged my knees. I would have said, "Yes, Judge. Yes, Judge." No, absolutely, you fight, man. You got to fight. That's what you're hired to do.
Yeah.
Right. They pay a lot of money, and they pay it just for something like that because they know that military defense counsel. I love those guys, man. I used to be one of those guys. They're not going to do it, or if they do it, they're going to be very, very vanilla about it.
Yeah.
They're just going to get enough. Like,
Cautious.
we got it on the record. We got it on. Don't worry. You got it on the record. You got to fight, man. Just like Rob said, you got to get it on there. Like you got to tell that judge, hey, I know what kind of crap you're pulling, and you might be able to push these guys around, but you're not going to push me around.
Yeah.
I want to be clear about this. I've never been treated this way by a judge in the court.
No, I think this is rare. This is extremely rare.
Now you have a situation where a judge didn't disclose something they should have disclosed, and that's a little bit different, right? And there may be some ethical issues there too, but by and large, Matt, military judges are incredibly professional.
Well, except for one guy.
Well, there's anything else, there's some bad apples out there, but
there's something that happened down south.
I have never had,
because they have the experience, right? They have the experience to be sitting where they're sitting.
Absolutely.
You would hope that they are.
Absolutely.
And it sounds like in almost all cases they are. But
Absolutely. And I think that's important to mention. I think this is an outlier, but it shouldn't be tolerated. And I don't know what this judge is doing now. I don't know what the Army's decided to do about keeping her on the bench or whatever. I'm not in a position to talk about that, but I can tell you right now, if I show up at a trial and this judge is on the bench, they're absolutely going to be a challenge.
902 right then and there.
Absolutely going to be a challenge.
Not even a problem.
I'm sure you both will do good work for your client, and I wish him the best. And, it's an example, I think, that's worth highlighting. You have to bring this stuff to light, and I think you probably helped prepare some defense counsel for this, because it won't be the last time it happens, I'm sure.
Well, I know we're wrapping up, but one fact that, in another episode, we talked about the permeance of the sexual assault training that's happening, the re-education. This judge was a former special victims prosecutor.
We don't know. We don't know. No, I don't know.
Okay, I don't know. Okay, then never mind. Yeah. What I was going to say had to go along those lines, but since we don't know, I don't want to say anything that isn't true or accurate. So
you got to be careful. I guess the point Mickey's trying to make, you got to be careful. You got to know who judges are, right? Yeah. You got to know who your judges are, because some judges have a background that may make them more friendly to one side or the other, even unintentionally, right?
Yeah.
But
and that's what the challenges exist for, right? I mean, the challenges that you're talking about, those are on the books, and they exist for that reason.
Right.
So
I've never experienced anything quite like this, and quite frankly, I think it's very, very rare. And I hope the Army should remove her from the bench. That should happen. Yeah. I don't know if that will. That should happen.
Well, we will be watching it for sure.
That's right.
I mean, that might be exactly what the Army wants.
Yeah.
You know what I mean? You never know.
They might make her the prosecutorial convening authority for all sex assault cases. Then, my God.
Well, good luck to you guys both on the case, and we'll report back.
All right.
Thanks, Matt.
All right, guys.
This session is adjourned.